Thanks so much for joining us today for the distinguished visitor lecture delivered by Professor McDougall. Professor McDougall joins us all the way from the Peter A. Allard School of Law at Allard Hall at UBC. It's my distinct pleasure to welcome Professor McDougall because he's in fact my doctoral advisor and also, I think, a very eminent scholar in the area that I work in. To give a full introduction for Professor McDougall would take more time than we have, unfortunately, because his list of accomplishments, publications, and honors would simply not permit us to have also that and his talk. So I'll just say briefly that Professor McDougall is, without a doubt, one of Canada's leading scholars in private law. And his research tackles a number of topics that are treated by most as being very tough. These include secure transactions, estoppel, misrepresentation, and as of late, mistake, which those of you who are aware of the law of mistake know is very difficult, and those who have yet to study it with me will find out it is very difficult. I would note with some chagrin that Professor McDougall's interest in mistake began not long after he took me on as a doctoral student, although he assures me that the timing is coincidental. But without further ado, I will now leave Professor McDougall to give us his thoughts on mistake as a protection for third parties in contractual relationships.
Thanks, Krish. Can you hear me, by the way? This microphone I was supposed to turn on, and I'm never sure whether these things work or not. But I was here a few years ago talking about something to do with sexuality in law, so it's sort of now for something completely different. It gives me a great pleasure to talk about this subject of mistake. I just submitted a book manuscript on the law of mistake in contracts. And so some of what I'm dealing with here arises out of questions that I had while writing that book. I've been asked to talk, I think, for about 30 to 40 minutes, and so I will proceed to give you what I have here, and then I think there'll be some time afterwards for questions. What I'm going to be saying is fairly complex and complicated, so if you've had a dose of caffeine or two, it probably would help you, but in any event, that's the subject. The third party aspect is a little bit misleading because it's only the fourth part of what I'm going to talk about. What I want to talk about is the law of mistake and why it is famously avoided. Many contracts courses actually decide to delete it. Professors often put it on their syllabuses, and then when running out of time, the first thing to go is usually the law of mistake or something connected with it. And so I want to talk a little bit about why mistake is necessarily complex, but then I also want to talk about why the law of mistake is also confused. And it's the third parties relate to some of the confusion that arise, in my opinion, with the law of mistake. So I do want to talk about four aspects that give rise to the complexity in the law of mistake. First, I want to say something about contract law in general. Secondly, I want to talk about the common law and equitable divide that besets this area, well, the law in general. Thirdly, I want to talk about mistake itself and how that contributes to the complexity. And then finally, I want to talk about the role or the position of third parties within mistake. And it's my suggestion that that's where a lot of the confusion arises. There's complexity there as well, but when coupled with confusion, it makes sometimes mistake a very difficult doctrine to take on. Third parties are often neglected in assessing contract law because the focus is very sharply on the two parties to the contract and their relationship with each other. Mistake is paradigmatically a mechanism for empowering and protecting the parties to the contract, but it can also be a mechanism for empowering third parties and for protecting them. And the law of mistake is an excellent vehicle for understanding how that does or might work. While the rules of contract are usually worked out with the two parties to the contract in mind, third-party interests typically enter the consideration as exceptions or as discretionary matters. And as there are many, many third parties in contract situations that actually get litigated, the accretion of these exceptions to the rules is what, in my opinion, leads to the confusion. But first, before moving on to third parties in this area of law, I want to say some general words about two main elements, contract and mistake, along with the common law and equitable divide, before turning to how third parties might fit into this scheme. With respect to contract, I don't want to say too much about contract law. That would take more than just 30 minutes. But I do want to define it for the purposes of what I want to talk about. And then I want to say something about the fate of the contract once it is in place. So with respect to the contract, I define it for our purposes as a consensual relationship allocating risks as between two parties in relation to a specific matter or specific matters. Now, once this set of obligations, that is, this set of intangible property, is brought into existence, what might be the fate of the contract? And also, within those fates, what might the role of mistake be? Well, the first possible fate of the contract is that its obligations could be performed, or if they're unperformed, they could be enforced. And here, if mistake is present, it is an irrelevant issue. Unless for some reason the mistake has become the subject of an obligation in the contract. We'll come back to that a little bit more later. The second possible fate of the contract is that its obligations could be unperformed but also unenforced. And why would they be unenforced? Well, because it is seen to be unseemly in some way for the institutions of state, that is the courts, and the law itself to be involved with the obligations. And this could be because of a mistake. And here, mistake is a paralyzing element. The third possible fate of the contract is that the contract actually could be said to be non-existent, and therefore there are no contract obligations. And why would that be? Well, because one of those elements that I referred to earlier, needed for the contract to be said to exist, is missing. That is, there could be perhaps no consent, and that could include possibly because there's lack of clarity about what apparent consent relates to. It could be because the existence of one or more of the parties is problematic, or the non-existence of the subject matter of the contract. And mistake of certain types fit in here. If so, mistake here is a preventative element. And it can be said that despite the presence of all those other good things that are perhaps needed for a contract, there is an element present, that is mistake, that is not supposed to be there. And that prevents the other elements from combining to make a contract. The fourth possible fate is that the contract could be reversed and time turned back to the pre-contract, that is the non-contract world. And why is that? Well, because the contract ought not to have been created. It was created, but it ought not to have been created. Why could that be? Well, for a number of reasons, possibly because the conditions for consent were fatally flawed in some way, or the conditions for understanding the existence of the other party or the subject matter were flawed. Here again, there can be a mistake, and if so, it is a destructive element. The fifth possible fate of the contract is that the contract could be altered. Why would a contract be altered? Well, because superficial appearances relating to the contract do not match objective reality. And this could be because of mistake. And if so, mistake here is both a vitiating element with respect to the apparent contract and an enabling element with respect to the real contract. And so therefore there are five possible fates for a contract in which a mistake has a role, and that role could be irrelevance, it could be as a paralyzing force, it could be as a preventative force, it could be as a destructive force, or it could be as an enabling force. And so already you have the complexity of mistake, that it can actually do various things depending on the circumstance. Now these fates and the roles that mistake might have play out in the two legal systems that we have, or at least the two that I'm interested in for these purposes. That is the common law and equity. And these systems themselves add to the complexity. And you have to understand the difference between the two legal systems, particularly in the context of contract. The role of the common law, particularly the common law judge, is very much like that of a referee, deciding which player is correct. In this case, the one who wants the contract or the one who doesn't want the contract. But anybody, including the players in the game, but also third parties, can ask the referee for a decision. Equity, however, sees the role of judge as judge and scrutinizes conscience within the context of a given relationship, and therefore is apt to examine the fairness of the relationship between the two parties, and in a sense choose a good guy and a bad guy perhaps, but also takes into account how any further action that the judge himself or herself might make, how that would play out in terms of fairness to others who are now implicated in the relationship of the two parties. That is, how it would have an impact on third parties. Now, within the contract fates, the 5 fates that I just mentioned, I don't think the Greeks had 5 fates, but anyway, we have 5. Common law and equity have developed distinct roles. Though I'm the first to admit that the history often cited to assign those roles is rather dubious in many cases. The first fate was related to the existence of the contract and its enforceability. Here both common law and equity have a role. Common law alone has a role with respect to the existence of the contract, but with respect to enforcement, both equity and the common law have a role. With respect to the second fate, that is the unenforceability of the contract, at least in the sense that I described it, that is a role that equity plays. The third possible fate, that is the non-existence of the contract, as with existence, the first fate, that is for the common law alone to decide. The other 2 fates, that is the removal of the contract or the changing of the contract, those are both roles that equity is thought to play. So again, we have a complexity built in. So the fate, the contract itself, and the possible fate of the contract, and then which legal system we're dealing with, and how that legal system approaches contract matters, including mistake matters. So what about mistake, which is the third element that I want to talk about in this complex state of affairs? Well, mistake has many possibilities, many reasons why there might be a mistake, and it also raises many questions. First, more theoretically, it is not altogether clear what it relates to in terms of why we have contracts. So does it relate to intention? Does it relate to consent? Does it relate to knowledge? Does it relate to motivation? And then also there's the question of why that would matter, what it relates to. While mistake is obviously connected to defective knowledge, in fact they arguably are synonyms, defective knowledge per se has no consequences in the law of contract. In my view, mistake is probably most relevant to the issue of motivation. And it is the defective knowledge that leads to a particular motivation that is problematic in the law. But in a sense, these various elements that I've talked about are all part of a linear set. So if we have a mistake, that leads to defective knowledge, which leads to a misplaced motivation, which leads to an inadvertent detention, which leads to flawed consent, which leads to the contract. And so if mistake is present, it means that there is a contract built in some way on a mistaken foundation. Whatever the more theoretical reason as to why mistake is relevant in the contract, mistake can certainly relate to various things in a more practical sense. So it can relate to the obligations in the contract. And it could relate to the existence of the obligations now or how the obligations play out in the future. It can lead to mistaken assumptions that form the background for the creation of the contract. Or it can lead to a mistake with respect to the record of the contract. And I'll come back to this complexity shortly. One of the reasons why we need to know, though, what the mistake relates to is because what its presence does in terms of the fate of the contract depends on the nature of the mistake. That is the non-existence, unenforceability, reversal, alteration, and so on, those various consequences that I mentioned earlier. The complication is that these particular responses relate to particular types of mistake and to use by particular persons. And it's the coming together of these aspects, the definition of mistake, the persons involved in the mistake, and the consequences of the mistake that makes this area of law complicated. But mistake has a further complexity because it can be divided for purposes of the law of contract in a temporal way, by virtue of its timing in relation to the creation of the contract. It could relate to a mistake now or in the past, that is with respect to the time the contract is created, or it can relate to a mistake in the future, that is a mistake within the contract period. Now, taking that second one first, mistake in the future is troublesome because if it were allowed to operate broadly, it would effectively reassign the risks for the parties that they have allocated in the contract. Nonetheless, there are two areas of law, that is doctrines of law, that do allow this in our legal system. One has been around for a fairly long time, and that's the law of frustration. The law of frustration relates to the future. It's not directly related to the performance of the contract. It relates to an unexpected catastrophic event, that is a mistaken prediction that the parties have made, in a sense, about the future. Another area about mistake into the future is, however, directly connected to the performance of the contract. And this is the newly invented duty of honest performance, about which Krish Maharaj is the expert, so I won't say too much about that, but you can direct any questions about that to him. And I don't quite know how that plays out. It's very new. But it is certainly apparent, according to the court, an induced mistake of one party by the other party in the process of performing the other party's contract obligations. More usually, mistake relates to something that's in existence at the time the contract is created or in the past. And these types of mistakes are generally categorized in two big categories, and that is a mistaken assumption that has been made, or a mistake as to the contents of the contract. Now, a mistaken assumption could be a mistake about the other party's identity, or which has its own area of law, or its own body of case law. Or it could be a mistake as opposed to some other type of assumption, aside from the identity of the other party. Both these two types of mistaken assumptions, that is, mistake as to identity or a mistaken general assumption, can actually overlap with a third category of mistaken assumption, and that is a misrepresentation. Both of those can lead to the context for a misrepresentation. A misrepresentation is a mistaken assumption induced by a representation of some other person, possibly the other party to the contract. Misrepresentation always relates to a mistaken assumption, but a mistaken assumption does not always involve a misrepresentation. But because of this overlap of these areas, mistaken identity, misrepresentation, general mistaken assumption, there is some complexity or even confusion involved as to what do I do with this particular issue. Is it a misrepresentation or is it a mistake or some such thing? There could also be, though, with respect to mistake now or in the past, the other area, which is the mistake as to the contents of the contract. And that could be a mistake as to the very essence of the transaction, what the transaction is all about. And that is the domain of the law of non est factum, which, rather confusingly, can also be a context for the law of misrepresentation. It could be a mistake not as to the nature of the transaction, but as to the terms of the contract. But that, rather confusingly, if the terms are important enough, can also be a mistake that's non est factum, because it could be so important that it leads to a different type of transaction. And then finally, with respect to mistaken assumption, you could have a mistake with respect to the written record of the transaction, and that's the domain of the law of rectification. So that's a complexity, another layer of complexity within the law of mistake. And then finally, the other complexity relates to who is mistaken or who needs to be mistaken so as to have the mistake lead to any consequences. Now, mistake is largely in the control of or is the concern of the parties to the contract, whether we're dealing with equity or at common law. The mistake is somehow a manifestation of the idea of unconscionability, both at common law and in equity, in a very wide sense of unconscionability, as the Supreme Court of Canada accepted very recently, very wisely, accepted very recently in the context of proprietary estoppel. Now, equity will typically allow one party to assert that party's mistake against the other party so as to get a particular result. so long as the party seeking the attention of equity is excusably mistaken, that is, not at fault, and the other party is somehow blameworthy, either by having caused the mistake or having known about it and said nothing. A different way in which unconscionability relates to a mistake and the parties is with respect to the non-existence of some of those elements that I mentioned earlier that were required to have a contract. Now, the law here says that it actually can be inappropriate to say, that is unconscionable to say, that a contract exists between the parties. And here both common law and equity do get interested. The common law being fixated on existence versus non-existence, and equity destroying what the common law says exists. So those are the three elements I want to start with. Before I turn to the role of third parties in all this, though, I want to draw together those three elements to set out the schemes. These are the doctrines of the law of mistake. The first one is a law of frustration. Some of these, if you've studied contracts or are studying it, you probably already have dealt with. One is the law of mistake. In the law of mistake, both parties have to be mistaken. It's a common law doctrine, and it leads to the absolute termination of the contract. The next doctrine is the duty of honest performance, which is a mistake of one party. The other party cannot be mistaken. It's not clear in my mind, it might be clear in Professor Maharaj's mind, as to whether this is a common law or an equitable doctrine, nor is it particularly clear to me what it leads to in terms of consequences. It could be the doctrine of misrepresentation, or rather one of the doctrines of misrepresentation. Here, if it's fraudulent misrepresentation, one party is mistaken. If it's a purely innocent misrepresentation, both parties will be mistaken, at least legally. If, however, it is the type of innocent misrepresentation called negligent misrepresentation, it could be that both parties are mistaken, or possibly only one party is mistaken. Here, both the common law and equity govern. Common law governs the tort aspect of this, so you get the tort remedies in certain cases, and those are damages. With respect to the contract remedies, those are equitable in nature. So the rescission of the contract, which is usually thought of as equitable, it's not really equitable, but anyway, usually thought of as equitable, and the denial of certain equitable remedies are the contract responses to misrepresentation. The next doctrine of the law of mistake is a mistaken assumption. Here, both parties have to be mistaken. It's not clear whether this is entirely a common law doctrine or whether possibly equity adds to it. The next doctrine of mistake is a mistaken identity with respect to the other party. That, by its very nature, will usually involve one person being mistaken. It would be rare that both parties are mistaken about the identity of one of the parties to the contract. Again, there is some lack of clarity here as to whether this is a common law doctrine or whether this is an equitable doctrine. The doctrine of non est factum is usually a mistake of one party. This is always said to be a common law doctrine, but it actually sits uncomfortably here. Mistake as to the terms of the contract. If one party is mistaken, that is an equitable area of law. If both parties are mistaken, it is the common law that applies. If it is a mistake, finally, the last doctrine I have to give you is the mistake as to the written record. That could be a mistake of one party, or it could be a mistake of both parties. It's the law of rectification, which is always said to be equitable, although it acts very clearly as though it were a common law doctrine. So I'll come back to that shortly. So those are the various doctrines. Depends on the parties who are involved. Sometimes they sit within common law, sometimes they sit within equity. They lead to particular consequences, but whether, if it's a common law doctrine, that should be a doctrine that anybody can argue. If it's an equitable doctrine, it will tend to be only one of the parties able to argue that there should be consequences. All of these mistake doctrines relate to asserting the primacy of the truth. They are methods the law tries to get the parties back to the truth, what would have happened if the truth had prevailed. There is, however, yet another mistake doctrine that you'll be glad I'm not going into, and I haven't mentioned it so far, and it does the opposite, and that is it holds the parties to the mistake, that is, to the falsehood rather than the truth, and those are the doctrines of the law of Estoppel. Whatever the complexities that arise from all of this, and they certainly are there, I concede that, one thing is fairly constant in what I've said, and that is a mistake is a matter that involves the two parties to the contract. This area of law is complex, but there is a certain logic about it if we clearly delineate the nature of the mistake, when the mistake occurred, who is mistaken, and the legal system that typically deals with that particular combination. And then that will tell us or lead us to one of the fates that I mentioned earlier. What about third parties? Well, they haven't figured very much in what I've said so far. The mistake, as I've said, is the paradigmatic source of personal rights and obligations between parties. It is a world the parties create for themselves, and outsiders are really meant to be outside the contract. But that is not really the case, or at least not entirely the case, in either of the two legal systems we have, common law and equity. And strangely, in both legal systems, there are paradoxes as to the role that third parties should play. Third parties do have roles in common law and equity. In contract law, the common law is the creator, but third parties have a role of denier. In equity, in contract law, equity is the destroyer, but third parties here have the role of preserver. So in other words, in contract law, the common law is the great creative matrix, equity having no real role anymore. At common law, third parties are irrelevant to the creative processes. The two parties are the creators. But third parties are able to argue that the two parties did not have the ingredients to have been able to create the contract, and therefore they cannot be said to have done so. In equity, third parties are irrelevant to the initiation of the destructive processes, either through rescission or unenforceability or rectification, but should be impediments who can preserve the status quo, whatever that is, the existence of the contract, the existence of the non-performance of the obligations, or the existence of an erroneous record. Sometimes third parties do fit into this scheme in a logical way. They play the role they should play. So in certain areas, for example, in misrepresentation, or in frustration, or with respect to the law, a mistake is two terms, third parties generally play that role. That to the extent that it's a common law doctrine, third parties can argue the mistake, so as to prevent the contract from being said to exist. If it is an equitable area of law, third parties play the role of inhibitor, preventing anything from happening that the parties want to undo. Unfortunately, however, in certain other contexts of mistake, third parties disrupt what I see as the common law, equitable, complex elegance that might otherwise exist. And it is arguable that the confusion in the law of mistake, or at least most of the confusion in the law of mistake, although certainly not all of its complexity, arises because of the disruptive practical effect that third parties have had on predicting how the law should and will act. And I want to finish by giving you a few examples of this. For example, non est factum. Non est factum is governed by the common law. Everybody says that. And the result, everybody says, is that it makes a contract void. Because if there's non est factum, it makes the contract void, there is no contract, any third party should be able to have the same role here that the third party would have in, for example, a mistake as to terms. That is, to be able to argue that there is no contract, and therefore to prevent its existence. But in reality, what the cases have done is to give to third parties the preservative role in non est factum that should follow from an equitable characterization of the doctrine. And how that's achieved is somewhat different depending on the jurisdiction or the cases involved. There is authority, for example, that only the mistaken party to the contract can plead non est factum, not a third party and not the other non-mistaken party to the contract. This is very characteristic of an equitable doctrine. For example, misrepresentation can only be pled by the person who was the representee, not by a third party, and certainly not by the person who misrepresented. But in non est factum, unlike in misrepresentation, as the contract is void, third parties should not have a preservative role, which they do have in misrepresentation. If third parties can preserve a contract that should be void, third parties, paradoxically, effectively have the role of bringing a contract into existence that the parties have not created, which is a very odd thing, legally speaking. Now, some courts, particularly courts from this province, Manitoba, have in the past outright said that third-party interests are, in fact, an obstacle to a contract being void for non est factum, leading to the peculiarity that I've just mentioned. Most courts in most other jurisdictions achieve a similar result by inserting into non est factum a carelessness assessment, with carelessness usually being used not to protect the other party to the contract, who is typically blameworthy, by virtue of having misrepresented to the mistaken party, but to protect third parties who would otherwise be affected by the doctrine. Carelessness, therefore, usually being argued in contexts of third-party interests when non est factum is argued. The result is an ambiguity as to how and why third parties can affect non est factum, and a confusion about why a common law doctrine acts in a way that an equitable doctrine should be behaving. Another example is the law of rectification. Rectification is always said to be an equitable doctrine, just as non est factum is always said to be a common law doctrine. But rectification, at least in the context of third parties, behaves like a common law doctrine, and it's not clear why that should be. So if, for example, there's a common mistake, even if both parties agree that their written record ought to be changed, third parties can prevent that. Third parties have a preventative role here, which is a very common law role. A typical example, for example, being in the fairly recent Fairmont Hotels case from the Supreme Court of Canada, where third parties were able to argue that the two parties to the contract who wanted to rectify their contract couldn't do so. They didn't fulfill the necessary prerequisites to achieve rectification. However, on the other side of that, where the elements of rectification are there, third-party interests are usually ignored, which is unusual for an equitable doctrine, but is common in a common law doctrine. And so the contract can be rectified whatever the third-party interests are that might be affected. The contract is treated as though it had been worded always in the corrected form, that it is retroactive in nature. And if there are third-party interests, which tend to be taxes having been paid, fees having been paid, dividends paid out, and so on, those simply have to be returned by whatever third party received them. And so in function, this operates on third parties in a very common law way, as if the contract were void. The two other areas where there's a confusion here are the law on mistake as to identity and mistaken assumption, both of which, as I mentioned earlier, the law is still unclear as to whether that's a common law doctrine or that is an equitable doctrine. As some of you know, depending on what you've studied in contracts so far, in the law on mistaken identity, the most recent case, it's not that recent, but is the Shogun case from the House of Lords, 15 years ago or so. Which said this, that if you have a contract that's entered into in documentary form, then if there is a mistake, that operates in a common law, and the contract will be void. If, however, the contract were entered into face-to-face, then the contract is not void. But if it's affected at all by a mistake, it will be affected in equity, probably through the law of misrepresentation, making the contract voidable. Why on earth there should be any difference between a documentary contract and a contract entered into face-to-face is somewhat unclear. In that case itself, it was said to be a documentary contract, but it was a documentary contract entered into face-to-face, and so the peculiarity sort of piles upon peculiarity. The effect of, in the Shogun case itself, what happened is that because the contract was void, a later party who thought that he had bought the car lost the car, on the basis that there were no contracts in place earlier so as to give him a property interest that he could rely upon. And we're left wondering why that is. That doesn't seem very fair, that a third party is the one who pays the price. It's the innocent party, and so on and so forth. What you don't know from the case, but you can find out if you look at the way the case was argued, is that this third party was actually blameworthy. and so in a sense deserved to lose the car because that third party actually ought to have known that those earlier contracts were problematic. But the court doesn't tell us this. And so we're left puzzling about this poor third party who is hard done by in the common law, why this wasn't dealt with through equity. But if we know the facts, we understand why in that particular case there is some justice to the result. And finally, with respect to mistaken assumption, aside from mistaken identity, here the law, especially in England, is very ambivalent about whether mistakes operate only at common law or operate in equity. And this is the result of a confusing trilogy, which if you haven't done it already, you will do if you do the law of mistake. And the first part of that trilogy is the case of Bell and Lever brothers. Bell and Lever brothers talked about mistaken assumption being a common law doctrine and didn't say much about equity. That was followed, as you will learn or already know, by the case of Solly and Butcher, which said, no, this is an equitable doctrine and common law doesn't have much of a role at all. That was followed most recently by the Great Peace case in England, which said that no, it's a common law doctrine at all and there's no role for equity. And so what we're supposed to do with this ambiguity is anybody's guess. The ambiguity in practice hits hardest on third parties. For the parties to the contract, there is functionally often very little difference between a void and avoidable contract. It is in fact third parties who carry the burden of a void versus avoidable contract. And what courts often do is try to find the doctrine that serves the interests of justice with respect to this particular third party. And that search for a particular result just leads to confusion in the law when we have another case, a subsequent case with somewhat different facts and a different third party. So in conclusion, I suggest that the confusion in the law of mistake is partly because of the complexity of mistake, and there certainly is lots of complexity, but that can be resolved through careful delineation of who and what is mistaken. Even with respect to third parties, the law is complex, but it can be made predictable. It is, however, in my opinion, the way the law deals with third parties in practice that puts paid to any logic or predictability that can be distilled from the many cases in many areas of contract. That said, however, even if the law were to pay more careful attention to the delineation of who does what and what the result should be, it will probably always be the case in the law of mistake that the 1971 words of Justice Thompson in the case of McMaster University and Wiltshire Construction will ring somewhat true. He said that in the application of any particular decided authority relating to the topic of mistake as applied to contracts, one must exercise caution. Not only is it a difficult and elusive topic, but some confusion has arisen in the cases as to the distinction between the legal and equitable principles to be applied. The principles upon which the courts will intervene and the circumstances in which they will do so have not been precisely settled, and the decided cases are open to a number of varying interpretations and are difficult to reconcile. Thank you very much.